Thank you so much, members of the committee. Glad to be here. I'm going to talk very fast. Feel free to hit me with any questions.
Introduce yourself, too.
I'm Chris Sevier, former Judge Advocate General, Vanderbilt Law School, Vanderbilt undergrad, was a federal prosecutor, constitutional federal litigator. So basically there's been 29 states that have moved on this bill. Democrats are the prime sponsors in 3 of the states. In the state of Louisiana, a House member took one of their 5 bill slots to introduce the bill, and so did Senator Morris. And so basically, I'm going to try to hit 4 points. Number one, the first question is what's the best solution to the ongoing problem of social media censorship, the bipartisan problem? Is it an executive order by the president? Is it Senator Josh Hawley's attempt to repeal Section 230 of the Communications Decency Act, or is it Senator Morris' bill? And the answer is it's his bill, because he has a bill that's narrowly tailored to fall within what's called the state law exemption under Section 230 of the Communications Decency Act. It's subsection E, subparagraph 3. So I'm a simple guy. I like to understand things breaking down in simple terms. So what is Section 230 of the Communications Decency Act? It's a federal statute that was passed in the 1990s that creates an immunity defense for internet intermediaries. It was designed to allow the internet to grow, but it was part of the Communications Decency Act, which was designed to stop indecent speech, not to promote deceptive trade practice. So still, what does this mean in plain English? Well, the best way to understand Section 230 is through an example. So if somebody posts a defamatory comment on YouTube, the person that was defamed, if they sue the person who defamed them and they name YouTube in that lawsuit, then YouTube can invoke what's called a Section 230 immunity defense and have the case dismissed against them. But there's an exemption in this state statute. If you file a law, if this state enacts a statute, once it's passed, if someone brings a lawsuit pursuant to the statute, it will fall within that exemption and pierce through it. They can't raise that immunity defense. So that's point number one. That's why this is not one of many solutions. This is the solution. Other bills on this topic will be preempted under the doctrine of preemption, but his bill will not be. Point two, what does this bill say? I mean, what is it saying? It says, going forward in this state, if a user in your district of social media websites is censored by a social media outlet that has more than 75 million subscribers, that was never affiliated with a religious or political party from their inception, then the person who was censored would have standing to bring a private right of action pursuant to the statute, where they could seek statutory damages, attorney's fees, actual damages, and other forms of relief. And it's up to $75,000 in statutory damages, because it will create what's called diversity jurisdiction. It will give a litigant the option to litigate in state court or federal court. Here's another point. The state contract law is a state law issue. When a citizen in your district signs up for Facebook, Twitter, or YouTube, they're entering into a form of a contract. It's an adhesion contract, but nevertheless, it's a contract. And when a social media website like Facebook, Twitter, or YouTube turns around and censors your member of your constituents, what is happening is they're engaging in a form of existing breach of contract. It's bad faith. It's unfair dealing. It's unjust enrichment. It's fraudulent inducement. It's deceptive trade practice. As Attorney General Barr said, it's the greatest bait and switch ever, is basically what it is. And point three would be this. The opponents are going to get up here and they're going to say, this bill violates the First Amendment in some general vague way, but they won't be able to explain how. There's never been a case where someone has filed a lawsuit pursuant to a state statute designed to fall within the state law exemption to get around the problem of the doctrine of preemption. And so basically the First Amendment applies to the state. It doesn't apply to private companies. It restricts the state from basically passing policies that restrict free speech. However, bad faith, unfair dealing, fraudulent inducement, deceptive trade practices, those are harmful forms of speech. Those are non-protected forms of speech. While it's a restraint on the state legislatures from enacting statutes, it's also a catalyst. It's a trampoline. So you guys have what's called a narrowly tailored, compelling state interest to enact this bill, introduced by Senator Morris, because the tech companies have intentionally and deliberately set out to create a modern-day digital public square, and they've done it through fraud. And so this will level the playing field and stop deceptive trade practice, which is really hurting our democracy. We have Democrats as the prime sponsor of this bill. This is a bipartisan issue. They censor Democrat candidates running for office all the time if they're not woke enough, for example. One final point, and then I'll stop, and that is there's lots of exemptions. The bill is designed to parallel the spirit of Section 230. It mirrors it. So it pulls from language of Section 230, saying the tech companies can still censor for all the common sense reasons. If the content is pornographic, if it's excessively violent, if it's a false impersonation count, if it's copyright infringement, things of that nature. And so if you have any questions, I'll be glad to answer it. If you would like to recall me after the opponents testify, I'd be glad to rebut anything they have to say. But this bill really it will not be preempted. It will survive judicial review, and it's going to stop a systemic problem. And it's really the best solution to this problem. It falls in the hands of the state legislature to write a bill that will fall within the state law exemption under subsection E, subparagraph 3. And that's all. Thank you so much.
Okay. Senator Morris, you have anything else? You want to bring the opposition up? Oh, yes, sir. I'm sorry. Senator White for a question.
Sure.
Just a question, your 3 points.
Yes, sir.
They get immunity for false statements. That was point 1, right?
Point 1 was that this is the best solution to this problem.
Yeah.
Because the reason why this is the solution, there's not many solutions. Other states are trying to do some stuff. There's 29 states running this bill. Yeah. And this is the solution because there's a thing called the doctrine of preemption, which says if there's a federal statute that's inconsistent with a state policy,
right,
then, the feds are going to win. However, the Congress intentionally carved out what's called the state law exemption. So the states could pass statutes that would not conflict with Section 230, the spirit of what they were trying to accomplish, but would allow the cure abuses. So that way we don't have to repeal Section 230. It's actually good law. We think it should stay in place. But this narrow issue of people getting censored for their religious or political beliefs on platforms that have more than 75 million subscribers, who market themselves as being free, fair, and open to the public. If they came out from the beginning and said, we're a Christian website, or we're a moral relativist website, and we only promote this kind of narrow doctrine. If they let you know up front, that's the difference with the distinction. So,
okay, what was point 2?
Point 2 was really what the bill was. What is the bill? Point 2 was basically trying to sum up, what is in the bill. And it creates a private right of action. If citizens in your district are censored for religious or political reasons by a social media website that has more than 75 million subscribers, they would have standing to pursue a cause of action in civil district court or civil court, either federal court or state court, under this statute.
And that would be on any platform if it's more than 75,000.
If it's I think ESPN is here to talk about whether or not it's
55 billion.
Yeah, 75 million subscribers.
Okay.
I think ESPN is here to oppose the bill, but only on the narrow issue of, could it apply to ESPN? And really, the way the bill is written, it's designed to basically go after or to stop social media websites like Facebook, YouTube, Twitter that have really created those big social media platforms where you sign up and it's an interactive service. The way the bill is defining social media websites, it would really cover Facebook, Twitter, YouTube.
Okay. The third point was
Yes.
deceptive trade practice.
The third point, well, I kind of covered two things. One was to talk about how contract law is a state law issue. If this is really, the reason I bring that up is to show that you guys have jurisdiction here to regulate the tech companies, because, you guys can hold tech companies to higher standards of care. Tech companies that have marketed themselves as being free, fair, and open to the public, you can hold them to higher disciplinary standards by enacting the statute. And for several compelling reasons. I guess the third point was then the First Amendment issues. Okay, there's basically two objections to this bill. One is, if you don't like Facebook, Twitter, and YouTube, why don't you just go out and form your own Facebook, Twitter, and YouTube? Right. And the response back to that is, the reason why that's not a viable option really is because, they tried it with Parler, which only had 55 million subscribers, by the way, so it wouldn't be covered by this bill. Right. But, they took it down still. They figured out a way to take it down. But even still, these tech companies have reached what's called critical mass, and they have billions of people have signed up. I mean, millions of people in the state of Louisiana have signed up for these platforms and use them all the time. And, they're really being punished for if they say something that offends the delicate sensibilities of an employee that works at Facebook, for example, they're getting basically dehumanized. And so we're trying to stop what is a form of deceptive trade practice. All this bill is doing is it's trying to get existing law to catch up to modern day technology. And the other point I made under point 3 was First Amendment. The opponents are going to say this bill violates the First Amendment in some general, vague way. They're just going to float that out there and walk away. Certain groups do that all the time. but they can't really back it up. They can't explain how. And we'd ask the members to say to them, is deceptive trade practice protected free speech? Is breach of contract protected free speech? Is fraudulent inducement false advertising? And the answer is no. By enacting this statute, you're protecting your constituents. You're stopping an extreme form of abusive practice. And Senator Morris brought up Justice Thomas' position about how something needs to happen, and it's federal litigators who live and breathe in federal court. We're seeing the courts indicating something does need to happen, because what's happening now is a member of your constituency gets censored. They file a lawsuit against Facebook, Twitter, or YouTube, and they invoke the Section 230 immunity defense because they're just suing under some generalized claim, if you will. They're not suing pursuant to a statute that was narrowly tailored to cure this problem.
So what this statute does, it cures that action.
Yeah, this ongoing bipartisan problem.
So if you blatantly make false statements about someone or known to be false and trying to harm them,
if you knowingly published a false defamatory statement against someone on Facebook, Twitter, or YouTube, the person who was defamed could sue the person that defamed them.
Right.
If you sued Facebook, Twitter, or YouTube in that situation, then they could successfully invoke a Section 230 immunity defense. What this bill is saying is it's going against Facebook, Twitter, and YouTube. It's saying they market themselves as we're this neutral platform, and they are for the most part. However, they go in and they'll delete an entire account. We know tons of pastors who have said something like, I believe the word of God is true, and their entire Facebook account gets deleted. We have Republicans and Democrat friends of ours who were running campaigns, and all of a sudden they're being shadow banned because Facebook, Twitter, YouTube are favoring someone else, if you will.
Right.
And so what this does is it forces those platforms to remain neutral on issues of religious and political speech. And so if they censor you,
that was supposed to be from the inception that they were a neutral
they
body.
marketed themselves that way.
Right.
That's all they did.
I know people, they get banned.
Yes, sir.
Just for having a view
Yes, sir. That's right.
and not some kind of unlawful view, just a view.
Just a view. I'm a Christian. I mean, I make no apology for that. I mean, that is the worldview I believe in. But I want to see objections and criticism to that worldview and not see that speech get banned either. We need to have a robust debate because really, without truth, there is no freedom. Freedom comes from the truth.
Some things to incite people and things like that are harmful to society.
Yes, sir.
I can see that.
Right.
On some cases. But some people just get banned because of their view.
Right. So his bill parallels the language of Section 230. It's saying if the content is excessively violent, you can censor it with impunity. If it's pornographic, you should censor it. If it's if it's a false impersonation, if there's a court order telling you to take it down, if it's copyright infringement, if it's commercial spam, if it's spam of a commercial but not religious or political nature, right. I can censor that too. I mean,
calls for I understand. I just want to get a good
violence. Calls for immediate violence can be censored and banned under the act.
Content that's excessively
anything
violent.
that entices criminal conduct.
Yeah.
Someone that had an unknowingly nude photo that someone got a hold to and published it. Could you ban that?
Yes.
Obviously, yes, sir. Absolutely. First of all, that would constitute the crime of revenge pornography, number one. So that's a crime. And then second of all, the bill encourages that. And there's other bills being introduced that will basically strongly encourage them to censor things that are pornographic and obscene as nature, as the state of Louisiana defines obscenity.
And I say that because I know of cases where people were outside at their pool.
Yes, sir.
Behind a fence, and someone with a drone flew over and took a picture of them, and maybe their top was down. They were sunbathing the top part of their body.
Right.
And they put it on the internet. And then everybody in their community gets to look at it.
Right.
Yeah.
So that's a crime of revenge pornography.
Yeah, that would be a
Criminal
that'd be
activity.
a crime
And pornographic.
and could be censored under this act easily, and the person that did it could be sued.
Yep.
And nothing would inhibit them.
It could be criminally prosecuted for that. Actually, his language specifically is if the content is lewd, if it's obscene, if it's lascivious. Those are direct words pulled from Section 230. The reason why the courts are going to love this bill once it's enacted in all the states is because it honors the doctrine of preemption. We don't have to repeal Section 230. The courts don't have to. Justice Thomas's idea of we need to treat them as common carriers. We need to treat them as public utilities. None of that's necessary. All you have to do is the states just have to pass this bill. And we have Democrats and Republicans both signed on to this measure because it's an ongoing problem hurting us.
Okay.
Yes, sir. Thank you, Senator.
Okay, Senator Connick.
Thank you, Mr. Vice Chair. When we first got in and we talked about Justice Thomas, and I turned on the computer and did read some articles, that's when that ad popped up on me, so I apologize for that. Was Justice Thomas's opinion a dissent?
I think it was in a concurrence or dissent.
I don't know. I'm asking.
So what I've read from Justice Thomas is just things that the media is reporting on. I'm going to assume that it's in some opinion because he doesn't typically go to the media to just express his views. Nevertheless, what we're seeing from federal district courts all over the country is this is basically what the judges are doing. They're basically saying, okay, Facebook, Twitter, and YouTube, you censored PragerU and Laura Loomer and some pastor and so forth because they just have a view, as the Senator White said. They just have a view, they get censored. Well, they filed a lawsuit in federal court, and they invoke Section 230 of the Immunity Commission sees fit. Your Honor, this is a defendant.
I understand that part. I understand.
So what?
It was a concurring opinion.
Okay.
It wasn't a dissent.
Well, I'm reading one. No other justice sided with Thomas, who has long expressed outside views about the First Amendment.
Well, so
But it was a concurrence that no one joined with.
Okay.
That means he agreed with the result. You know, you're a lawyer, you know, he agreed with the result, but he added some additional comments that no one happened to join with. They didn't express the view whether they agreed or disagreed.
the significance, Senator, from my perspective as a litigator, federal litigator, constitutional litigator, is that the fact that the courts are speaking out about this, they're looking for the solution. They know it's a problem, and so they're looking for the solution. The point I was trying to make was that tons of federal district court judges are saying, well, we're going to dismiss the case for now. If a state, they're basically giving the wink, wink, nod, nod, that if a state like Louisiana enacts this statute, then they can't invoke it because it's got to, you could probably sue under the Lanham Act right now and under deceptive trade practice, consumer protection law, and probably win. Courts don't really want to see that.
So this is an emergent issue, you're saying?
This is an emergent issue, sort of. It gets existing deceptive trade practice law to catch up to modern day technology, involving social media websites that have, like the senator said in the inception, was that these guys have become way too powerful. They're way too abusive. They are out of control, and we need the state legislature to impose some checks and balances. If you guys pass this statute, you're going to allow the courts are going to be like, oh, thank God, this is the answer. This is the best solution. It's not one of many. We would respectfully submit. Go ahead.
Has any other state passed this type of
The
legislation?
29 states have moved on this. It's passed out of committees all over the country.
I'm asking any governor sign.
No governor so far has signed, although it has gone to the governor's desk in certain states.
And been vetoed?
Yes, sir. That's right.
How many states has been vetoed or not passed?
I don't know the total number. I know Utah, for example, is one of the states, but 29 states, Democrats are the prime sponsor. Democrats and Republicans have introduced the same bill on the same day in certain states.
But
And
the
then-
question is, has any of it passed?
No, it's, again, this is in legislation we've been involved in. It can take 7 years to pass a bill, especially
So
one.
the answer is no.
The answer at this time is that not yet, but we're getting close.
Okay.
And I don't see any reason why Louisiana should not pass this bill. And frankly, to be honest with you, we always ask the members to look out for their constituents and not worry about what other states. We're asking people to do this not because it's a right-left issue or right or left issue, because it's the right thing to do. That's what we're asking to do. We're not all these other ancillary considerations. The reason I'm here is to testify, if you pass the bill to stop a problem, to protect your constituents, would it survive judicial review? And the answer is yes, because it falls within the state law exemption. Is this a problem? Well, not only Justice Thomas is talking about it, it's the number one issue. It's conferences all across America that's both left and right. So, the question presented really is, what is the solution? What are we going to do about this? Do we do nothing?
Will if this passes, will the state likely be involved in litigation?
I don't think so.
person is?
This is a good question. We've got this question so many times because people say, here's what's going to happen. We're going to pass this bill, and Facebook and Twitter and YouTube are going to sue the state in court. First of all, I would say, never run from a fight, number one. Number two, they're going to say, we're going to get sued under Section 230, but that's not how that works. It would have to work like this. You pass the statute, common sense, consumer protection, deceptive trade practice statute. When the people that we know in Louisiana who are being censored bring a lawsuit pursuant to this statute, at that time, Facebook and Twitter, YouTube, whoever the defendant was, would have the right to invoke that defense. And at that time, the court would have to make the analysis, does his proposed bill, does the statute that was enacted, does it fall within the state law exemption? And the answer is going to be yes. That's what they've been waiting for.
Bottom
in my
line is the
opinion.
state wouldn't necessarily be involved when it'd be private lawsuit
Yeah.
between two private parties.
Could a solution be that Facebook would just stop dealing with Louisiana?
No, that's never going to happen. I mean, first of all, they've already engaged in these contracts. They've already signed up millions of people who live here. Now, not just Facebook, Twitter, and YouTube as well. So they're not going to just stop. I mean, because they're engaged, because we're saying, hey, Facebook, Twitter, and YouTube, why don't you just live up to what you promised? You marketed yourself as being this way to induce everyone to sign up, only to turn around and go, ah, ha, ha, we disagree with you. You know, that kind of thing. So.
Okay. What does the bill do about hate speech?
So in terms of hate speech, that's a political term. It's a religious term, is what it is.
Listen, this past election, there was a lot of hate out there, back
Yes,
and forth. So
Well, it's a really good political kind of like, what is, the thing about hate speech is it's very arbitrary. So we you know, law is reason without passion, right? So
somebody's hating you, you're going to know it.
yeah, I mean, you know, if someone is saying something hateful and you don't like it, you can block their account all day long. If someone posts a bad comment on your Facebook or Twitter, I mean, we have a lot of senators, representatives we work with that are like, I don't know if I can delete comments. We're like, delete them if you don't like them. You should be protected, but you could be able to do that. You have the free exercise right to do that, free speech right.
But is
But,
hate, under the Constitution, is hate speech protected?
It's not. It doesn't recognize hate speech because what is it? It could be anything. It could be. It basically is. Hate speech is whatever offends the delicate sensibility of the person who happens to be in charge that day. So it can be completely arbitrary and capricious. And so basically, that's not a legit. You know, while it's a current at this moment in time, like kind of topic to talk about, you can frame things as that to get leverage over someone as being hateful or so forth. In terms of the way the way the eyes of the law views it is it's arbitrary. It's bad faith, breach of contract. It's unjust enrichment. It's unfair dealing to say, well, we deleted the pastor because he said life begins at conception, or we deleted this
I
other
get that
person
point.
because
Is racist speech hate speech, in your opinion?
is racist speech hate speech? I would think so. I think it's deplorable. I think it's immoral. I think it's terrible. Everything that I believe in as a Christian would say that anything dealing with that topic is beyond the pale. It's unconscionable. It's first of all, it's absurd.
Okay. Would
Yeah.
Facebook be authorized to delete that type of speech?
So let's say
Yes, yes or no? Just
well, it's and in some sense it's not simplistic. If the KKK says they have their worldview, which I disagree with. Okay, so the KKK says we're going to go and do some act of violence at this time, and we're going to lynch someone to do something. They could delete that. However, if they espouse their worldview on racial superiority, in one sense, whether you know, there's all kinds of speech that I'm like the ACLU. You know, there's all kinds of speech that I really don't like, but I'm going to defend their right to say it, whether it be for the right or the left, whether it be something that's, you know, we get this question a lot. They're like, well, what about jihad? Isn't that religious speech? And we're like, well, yeah, you can say certain things on that topic, but if it's a call to immediate acts of violence, they can censor it.
what about, was it QAnon, whatever that is?
Yeah,
What are those guys?
I really don't know anything about them.
Okay.
So I'm not a subject matter expert on.
All right. To your bill on page 3, section E, it says a social media website shall not use the social media website user's alleged hate speech as a basis for justification or defense of the social media's website actions at trial. So you're taking away a defense.
Well, it's not really a defense. It never has been a defense. It never should be. But they basically, they could go and they say, Your Honor, clearly based on the modern day standard established by the Oscars or the people in Hollywood, this is hateful compared, because the new standard,
But you taking away a possible defense, a possible argument.
It's not an argument or a defense.
We're not in Hollywood. We're not in California. We'll be in Louisiana.
Right.
On the deal.
Right.
With Louisiana standards.
It's not taking away any defense because the law doesn't recognize that. The law is reason without passion. Politics recognizes things like that.
Then why you put it in the bill?
Well, because to make it clear, because we're trying to be expressly clear. A lot of times this is what they do. Facebook, Twitter, YouTube censors, like Tulsi Gabbard, for example. Senator Mike Gabbard from Hawaii, Democrats, the prime sponsor of this same bill, okay? His daughter, Tulsi, Democrat, she gets censored all the time. And Facebook's excuse is, it's hate speech. What does that
Who
mean?
decides if it's hate speech or not, the judge or the jury?
Well, the judge in that case is the employee who works at Facebook who's doing the censoring.
If it goes to court,
If it goes to court, then the
who's going
judge,
to decide if it's hate
then
speech or not?
court of competent jurisdiction will look at it and they'll say
But you're taking away that right to even argue the
they
fact
can
that-
argue it, but I mean,
But here's the point. Hate speech is in the eye of the beholder. You know, all of a sudden we have
I agree with you.
exactly. So censorship can be under a pretext of hate speech. You know, just like they say, the Representative Gabbard, is it Tulsi
Senator Gabbard,
Senator Gabbard is being censored into conforming to what the intellectual elite of her party insists should be the case, instead of open free speech under the pretext of hate speech, alleged hate speech. So, you know, people love and hate a wide variety of things, and some would argue that a lot of the things that are being taught, like critical race theory, promotes hate against certain races. Does that mean they shouldn't have the right to express that
No,
opinion?
I understand that, but I'm thinking you're preempting in this bill, in this section, you're preempting a defense that could be valid or could not be valid. It's either or, but it's up for the trier of fact to determine,
yeah.
is it hate speech or not hate speech? So why would you want to do that?
Well, the question, well,
But because it's the pretext of hate speech is being used to censor.
That's when you file suit and you can say you prove it's a pretext. But why are you excluding it in the bill outright? My concern.
They don't have the pretext. It has to fall within one of these things. It might be hate speech. It might be racist, but we have a free speech right to express our opinions, even if others disagree with them.
But
That's
the
the
bill
whole
says
point.
the social media, the defendant in this case, if it goes to lawsuit, cannot use hate speech as a
They'd
justification.
use it for
of
every defense. They'd use it as a defense every single time.
Well, if it's valid, it's valid. If it's not, it's not.
Well, what's hate speech? You're injecting this takes the nebulous concept of what or is not hate speech. It takes it out of the equation and makes it where you can say things that others might find objectionable or disagree with if it's based on their political or religious beliefs, unless it meets some of these other things, entices criminal conduct, calls for immediate acts of violence, is obscene or pornographic. I mean, that's the whole point of free speech. We may not like it. It might be hate speech, but that doesn't mean they don't have the right to say it. Or do we want speech codes? I mean,
Is
your
hate-
position,
is hate speech
your
protect-
position about a nebulous idea of hate speech is an idea of a speech code without a clear definition of what it is.
It's up to the trier of fact.
Right, but that is arbitrary.
Well,
Different triers of fact are going to have different opinions on what hate speech is.
And that's why you go to court to decide it.
One person might say somebody that really hates tolls is engaged in hate speech. You know, I mean, I know it's.
Well, I would go to court and have that argument. I can prove them wrong. So,
well,
but to
but
exclude
it's about
the
your
defense.
right to say it.
I understand
Senator
that, but
Connick. It's about your right to say it.
To
As
exclude
long
the
as it's not.
defense is problematic for me. Is hate speech protected by the U.S. Constitution?
Absolutely. So here's the answer. Here's the answer to the question, really. The point of that in the bill is to tell the judge and to tell the defendants, to give them notice that if you're going to go around and censor people based off of hate speech and try to justify it, which is really, as we all know, an imperialistic power play that's super jaded to even use that, for anyone to use that, for them to, Facebook, Twitter used to use that, it's so intellectually dishonest. Everyone knows that. It's common sense. The judge will be able to see through that easily. But there are exemptions and exceptions that parallel existing principles of law that say you can censor for these reasons. But if they say, well, we censor judge because it's hate speech, that is basically a way to just keep moving the goalposts. It's bad, contract, bad faith, unfair dealing. That's what that is.
That's
To
when you would
censor
file
for that.
suit. That's when you would file suit, and then you as a plaintiff would prove to the court that that hate speech that was used by Facebook to censor me was wrong. But to
if you
take
were a
away-
plaintiff that posted something religious
How
or
do you
political,
define hate
in nature-
speech?
It depends on the content, and that's for the judge or the jury to decide.
That's the point of this bill, is that things like that, people's opinions are being used, people in California.
I think that
probably-
that section right there is putting censorship on folks.
no, this is to stop the
I
practice
think
of.
it does the opposite.
That's right. It promotes free speech. It does
promotes
the
free
very
speech
opposite. That's right.
As opposed to censor speech.
But if the speech is hate speech, then there's a problem with it.
We don't know
Well,
what
If it
depends
incites
on-
violence?
Depends on whether I agree. Calls for acts of violence are excluded.
Okay. All right, I have no more.
Okay. Thanks.
Thanks, sir.
Thanks, Senator Connick. Okay, there's no more questions for you, Senator Morse. If we could bring up the opposition, James Lee, possibly? Eric Peterson and Larry Murray.
Welcome to Tulane Day at the Capitol.
I know, I missed
Just
out.
in, and
Goodness.
Mr. White was trying to figure out why I had on this outfit.
And-
Mr. Vice Chairman, my name's Larry Murray.
Okay, let's do a little house clean. We have a technical amendment that I'll offer. Staff wants to explain that real quick.
Working, I'm on.
Yeah.
This amendment is just, it is purely technical, clearing up, changing an R to an is and respacing a section.
Gotcha. Does anybody have any questions on the amendment? Senator White has a question on the amendment.
Just a question, who wrote the technical amendment? If Mr. Murray wrote it, I might want to study it a little bit.
Though creative, I think it was staff, so I think we're good there.
Still mentoring you after all these years.
Thank
Gotcha.
you.
We're going to give Senator Morse here a check to look at it. Gotcha. Okay. Are there any objection to the adoption of the amendment? Seeing no objection, the amendment is adopted. Go ahead.
Mr. Vice Chairman, my name is Larry Murray. I'm with the Capital Group here in Baton Rouge and here this morning representing TechNet, which is an association of the 60 leading technology companies in America, and they're here in opposition to this bill. I do know they sent a letter to all of you. I know you don't see every piece of mail that comes your way, but there is a letter that I hope will be placed in the record outlining their opposition to the bill. What I'm about to say next, I mean no disrespect at all to the proponents, but as a lawyer, I feel like I should just rest my case. If there's anything we've learned in the last 45 minutes, it's how incredibly complex this issue is. And I will say there was testimony that it's moving in 29 states. To me, that is evidence that there is an issue out there and it's being debated nationally and now in some state legislatures. However, I think Senator Connick was bringing out, the bill has not become a law anywhere. Yes, it's introduced and maybe being considered. I know 16 states have rejected it. I guess there are some legislatures that are still meeting, so you can't say it's failed everywhere yet, but it's failed everywhere where there's been the conclusion of session. I'm going to be brief. I'm just going to say that the social media platforms we're talking about, they review hundreds of millions of pieces of content daily. They do that through means of artificial intelligence, algorithms, and people being involved as well. I have no doubt that the review of that many things daily, that some mistakes are made. Absolutely. I'm sure they're made. I can't point one out to you. Maybe the Mr. White's drone situation. I just don't know. There are mistakes that are made, but this bill does not cure them. I do not see how anybody would think that we could have a state solution to this. If you just think about the testimony the last 30 minutes, all we did was talk about Section 230 of federal legislation and litigation. It's simply not, in my humble opinion, it's not an issue that we can resolve at the state legislative level. I know that Senator Carter has been paying close attention because this could be his issue real soon. This would take a national solution. The question was also asked, what would some of these social media networks do should a bill like this pass? Well, I know in Utah the reason that it was vetoed is there was great fear that what the platform folks might do is just say, hey, I'm in a trick bag. I just won't censor anything. We just let everything go through. We won't, and censor is maybe not the right word, but we just won't block anything or have any standards because we're safe if we do that. And the domestic awareness abuse advocates got really involved, worrying about it becoming more difficult to take things down, and they bore a lot of responsibility for having the bill vetoed there. So, we pay somewhat of a price in this country, I guess, for having the ability to communicate instantaneously with the world, and I just don't know how we think we can fix that in the Louisiana State Legislature. And I do think, Senator Connick, that if we pass such a law like this, I do think we might be involved in litigation. I mean, our AG would have the duty to defend any challenge of the constitutionality, and we could end up, I think, wasting some dollars there if we weren't careful. And I'll conclude. I'll stay up here to answer questions later. Turn it over to my colleague.
Okay.
Good morning. My name is Eric Peterson. I am the director of the Pelican Center for Technology and Innovation. It is good to be back in front of this august committee today. Unfortunately, I do oppose Senator Morris's bill. I think we all just heard about many of the issues regarding online speech and its removal from certain platforms. We've written extensively on this issue and indeed disagreed with many platforms removing of certain political speech. As Mr. Murray said, I think this is a complex and nuanced issue, and people with different ideas of speech are going to come down on any particular content moderation decision differently. But this bill is not a targeted approach to deal with this problem. Indeed, this bill would paint with a broad brush that would create a whole host of problems for the state of Louisiana, the internet ecosystem at large. You have heard extensively about Facebook, Twitter, and YouTube. I will read some other websites that would clearly be caught up in this definition. They include Wikipedia, Yahoo, Amazon, Reddit, Pinterest, Discord, CNN, Twitch, eBay, TikTok, and Shopify. These are nobody's idea of the new public square, yet they all take comments from users about certain issues. This would prevent them from removing sort of speech or just downvoting speech that is not useful to the people for they're looking. If you're looking for a product review and people are going off on a rant about politics, Amazon might have a good reason to remove it, as it doesn't confine for what they're trying to communicate on their platform. And indeed, that would open them up to $75,000 per deletion, as Mr. Murray said. These websites deal with millions of user-generated comments per day. I would say that this bill would be unduly damaging, not just to the companies that are right out, but potentially many more. I'd also say that indeed this bill does violate Section 230 and the First Amendment. There was some discussion about Justice Thomas's. I would point out that if you look at his comments, they were in the case of Knight versus President Trump. That had to do with Trump's Twitter account. I would note that in Thomas's comments, he talked about the platforms of Facebook and YouTube, which I find rather ironic. He was suggesting that one company that he was hearing a case on, he was upset that that case was ruled moot, and then proceeded to talk about other social media companies that then had a monopoly on and suggested they might have common carrier status. I would point out that Judge Kavanaugh has often looked to expand First Amendment rights for companies, particularly in the net neutrality debate, whether ISPs actually have a First Amendment right to reject carrying content. So the idea that there's some sort of conservative jurisprudence here that these companies are going to be common carriers, I think is far out. And I would suggest that the jurisprudence currently falls on the find that these companies have First Amendment rights. The case with PragerU was brought up in California that had to do with blocking certain videos to say that they were for adult only. They discussed violent themes, and not that they were actually blocked from YouTube, but you just had to say that I was an adult on YouTube to view that. There's also been some talk about unfair and deceptive trade practices. Again, AG Landry could bring a suit at any time if he feels that any of these companies were deceptive with the people in the state of Louisiana. There's also been some talk that these companies are too powerful. I would also note that Louisiana is currently on 2 lawsuits, one against Google and one on Facebook for antitrust grounds. If that is indeed found to be the case, Louisiana has remedies for that, and they are through antitrust. They are not through this piece of legislation. Furthermore, I would like to clarify one section about Section 230. I don't want to get deep in the weeds, though I can. The first part of Section 230 was not spoken about, but 95% of all cases through Section 230 are actually through the statute. It is very short. It says, treatment of publisher or speaker, no provider or user of an interactive computer service shall be treated as a publisher or speaker of any information provided by another information content provider. Again, that has to do with posting of user-generated content on some sort of website interactive computer service. We can get a little further into the definitions, but the courts have upheld time and time again that is a shortcut to the First Amendment for online companies, that they have the right to edit their content as they see fit. Thank you so much. I'm happy to take any questions.
Senator Moore for a question.
Thank you. Do you all agree that these social media companies have an enormous amount of power?
I would say that, like most things online, the social media landscape is quickly changing. Who here had heard of TikTok 4 years ago?
Let's get to my question. Do you believe that they have an enormous amount of power?
I think that they compete on speech, and that power is rapidly advancing in this space.
Do you believe that they have the power to squelch any competition that might arise that would allow content that they don't particularly like?
I see that they face competition in a variety of ways, so no, I don't.
My question is, do you think they can squelch it?
I think they can remove speech from their platform. I don't think they can remove it from the internet.
Well, isn't it true that Amazon Web Services removed Parler from their website, thereby dismantling that entire network with 50 million users, completely destroyed it?
Parler is now back online. You can visit at any point in time.
But they destroyed the user base for several months while they had to try to find other service providers. That's pretty strong. That's a pretty strong thing to be able to get rid of millions of users and stop a website from or a social media platform from operating for months because of your power. Don't you think that's an enormous amount of power?
There's a variety of cloud computing companies that Parler could have gone with, and many of them did not want to do business on Parler for violating their terms of service in that agreement. But that is outside the scope of this legislation.
But maybe they were. There was a lot of pressure applied to those other people to not to do business with them because of the power that these social media giants have. Isn't that true?
I can't speak to what happened with Amazon.
Okay.
And their decision making.
Let me ask you this: has Amazon or any tech company provided any sort of funding for your group?
We don't discuss our donors. We're a 501c3 organization. We take donor privacy extremely seriously.
So you're not. So you got dark money, maybe from these media companies, and now under the guise of public policy, you're going to criticize legislation to stop censorship of our citizens.
Again, we don't discuss our donors. I don't think I would classify that as dark money. In fact, there's an important Supreme Court case on Monday for the right to protect our donors from intimidation and harassment. And again, I have worked at multiple organizations, including the Institute for Free Speech, and I've held this as a consistent
Bottom
position.
line, you're just going to keep it secret who's funding you.
And Senator, let me just make clear on my behalf, I am a registered compensated lobbyist for TechNet and have filed all
Right.
the necessary papers for that.
I recognize that. And the group that you're here representing is, who's behind it?
There are about, and I knew somebody was going to ask it, there are like 60 different leading technology companies that are part of it. And I tried to, unless you're going to let me read them all, I wouldn't want to tell you who some of them are because I haven't talked to any of those individual companies and don't represent them. I represent only the organization. So it's all the leading technology names you could come up with.
Wait, and would it include the vendors of those companies, perhaps?
I don't think they have associate or affiliate memberships. I don't think, but I don't know that.
Not affiliate memberships, but like, for example, if Facebook is a part of this group, I don't know that it is or isn't. I would suspect it is.
I believe they are.
Facebook does business with hundreds, if not thousands, of other vendors that provide its services that they do business
And-
with, correct?
There could be one or two in there, I don't know. These are just leading technology names from every field.
Do they do
you could
business
think
with
of.
each other, those
Oh,
technology companies?
I'm sure they might do, yeah.
So they're all connected in some way, more than likely,
Well, I
wouldn't
can
you
tell you,
say?
they also, or if I showed you the list of bills we track, they're on opposite sides on some of the things too. So it's really an organization that was formed many years ago to sort of take a leadership role in advancing innovation and technology.
I see. Okay. So, thank you for asking my question, Mr. Murray.
The board is clear. Thank you all. We do have, just to read in, we have a letter from Mr. Esperanza, the executive. I'm trying to figure where Mr. Esperanza is from, in opposition to the bill. Also, a letter from Internet Association. Mr. James Hines is also in opposition to the bill. For the record, we'll put these letters into the record, and members, you have all that on your in your folder. Their opposition. Senator Morris, you want to close on your? I see no more cards to speak. Senator Connick, excuse me.
I have an amendment,
Okay.
and it basically deletes section E on page 3.
Okay, Senator Morris objects to the amendment. Do we Senator Connick, would you like to explain just deleting the section E just for those of us who
And we
haven't
discussed this.
memorized the bill?
It concerns me a great deal that we are preventing, before even an issue, we're preventing a defense of a defendant in these types of cases. And it says hate speech, the website uses alleged hate speech cannot be used as a basis of justification or defense under social media actions at trial. To have an actual trial going on and to prevent a defendant from using a defense of why they did certain things is just wrong in my opinion. So I would like to take that section out.
Okay, and Senator Morris has objected to the amendment. Hold on, Senator Morris, go ahead.
Yes, I object to the amendment. This would make it so nebulous for it to be enforced. For example, if somebody said that they think that boys should not play in girls' sports because they identify as a woman, somebody could have a religious or political belief about that, and that could be labeled hate speech, even though it's their personal political. And so Senator Connick's amendment is well thought out because it would completely gut the bill, and that's why I'm against it.
Gotcha. Okay. I see no more questions on the amendment. Senator Connick has put forth an amendment which Senator Morris has objected to. All those in favor of the amendment will vote yes. All those opposed to the amendment will vote no. If staff can...
Senator Abraham? Senator Abraham, no. Senator Carter? Yes. Senator Carter, yes. Senator Connick? Yes. Senator Fields? Yes. Senator Morris?
No.
No. Senator White?
No.
No. You have
I vote.
a tie.
Senator Henry, no.
Senator Henry votes no.
All right, that amendment fails. Senator Connick, to close on your bill.
I'll waive.
Senator Morris.
I'll waive closing and move to report it as amended.
Okay, Senator Morris has moved favorable on Senate Bill 196 as amended. If staff can call roll. As amended.
Who's objecting?
Are there any objections? Seeing no objection. Nope.
Senator Abraham? Yes. Senator Carter? No. Senator Connick?
Yes.
Yes. Senator Fields? Senator Fields, no. Senator Morris?
Yes.
Yes. Senator White?
Yes.
Yes. Senator Peterson? She's absent. You have 4 yays.
All right, bill passes. Senate Bill 196 is reported favorable by a vote of 4-2. We have one more bill on the agenda by Representative Hilferty. Mr.
Right on you.